So you're the heir of an estate and you don't know what's going on, and the person who is in control of the estate is maybe not as forthcoming as they should be. Hi, I'm Brenton Begley, attorney and partner with McIntyre Elder Law, and I want to talk about representing heirs. It's one of the things we do because, probate can be a complicated process. There's all sorts of different things that can go down within an estate process that gives rise to concerns. So, what happens when someone passes away and you have to go through probate is, someone has to be appointed as the administrator of the estate or the executor of the estate. If there's a will, they're called the executor. If there's no will, they're called the administrator. They're also called the administrator, by the way, if they're someone other than the named executor, okay? Because the named executor could have died or could renounce their right to serve to another person. All right, so what happens when you don't think the person is handling it correctly, meaning the executor or administrator? Well, there's some legal remedies that you may have, but to really know what those are, you have to seek legal counsel, because the personal representative may be doing everything they need to do. They're just not doing it within the timeline that you think they should, right? But the court has its own timeline where they're required to provide things like accountings to the clerk. Where we get really, really concerned though is where you have an estate where they're absolutely not doing what they should do, like providing a surviving spouse with the amount that they should have, providing updated information for somebody to be able to claim their share. Things like trying to keep somebody out of the house that's rightfully theirs, trying to, characterize a distribution as something that they've already received during their life. Things like that. We get these types of things all the time. And mostly in the context of surviving spouses and their ability to make a claim against the estate for their rightful share of the estate. For example, in North Carolina, you can't disinherit a spouse. And so a spouse can take their what's called elective share from a decedent's estate. And so what you'll have is someone who passes away, they have a surviving spouse, and maybe it's like a blended family. So you have a man who died, and then his wife is surviving him, and maybe the son or daughter of the man who died is serving as the executor over his estate and doesn't want to give the surviving spouse their share, okay? Or maybe, he signed a will that left her out. But you can't do that in North Carolina. Your spouse gets a share unless your spouse agrees to give up that share. So there's a lot of situations in probate where if you're an heir, you may need legal representation to ensure that the estate gets administered properly, that it gets administered timely, and that you get your fair share out of the estate. If you have questions about anything that we do, which is estate planning, elder law, we handle a lot of probate and litigation regarding probate, or anything we do, estate planning, elder law, right? Litigation in relation to that. If you have questions about that, give us a call because we want to help. 704-259-7040 is how you reach us, or you can visit our website, mcelderlaw.com, and schedule your free consultation.